In this presentation, we shall make a complete study of all aspects of the offense of murder and its punishment. We have already seen that when a death of a human being is caused by doing an act with the intention or knowledge specified in section 299, the offense of culpable homicide is committed. We have also seen that there are three components of mens rea in section 299: intention to cause death, intention to cause such bodily injury as is likely to cause death, knowledge that the act is likely to cause death. When death of a human being is caused by doing an act with any one of these three components, then the offense of culpable homicide is committed. Of these three components, wherever the first component is present, the offense of culpable homicide gets aggravated to the offense of murder. We can say, where there is intention to cause death, the offense of culpable homicide gets converted to the offense of murder. In case of the other two components, where the intention or knowledge is more pronounced and more sharp, then also the offense of culpable homicide gets converted to the offense of murder. The offense of murder is defined in section 300 IPC. This definition is in 4 parts or in 4 limbs, and it is subject to 5 exceptions. Here is the first limb. Culpable homicide is murder if the act by which death is caused is done with the intention of causing death. This is simple and straightforward. Wherever the act by which death is caused is done with the intention of causing death, that culpable homicide will amount to murder. This can be understood by the first illustration appended to section 300. A shoots Z with the intention of killing him. So A does the act. This act results in death of Z, and the act is done with the intention of killing Z. This is culpable homicide, and this is also murder. This is the second part of the definition of murder. Culpable homicide is murder if the act by which death is caused is done with the intention of causing such bodily injury as the offender knows likely to cause death of the person to whom the harm is caused. Here, the actus reus is causing the death of a human being by doing an act, and the act is done with the intention of causing bodily injury, and along with the intention, the offender also has a knowledge, and the knowledge is that his act is likely to cause death of the particular person to whom he is causing the harm. We can understand this concept by the second illustration appended to section 300. A, knowing that Z is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. The intention here is to cause bodily injury. The intention is not to cause death. If the intention is to cause death, it will be covered by the first limb of section 300. In the second limb, the intention is only to cause bodily injury, but the offender has a knowledge that the particular person who is being harmed is laboring under a disease, and the disease is such that a blow is likely to cause his death. In this case, A is guilty of murder, although the blow might not have been sufficient in ordinary course of nature to cause death of a person in a sound state of health. We shall now analyze the provisions of clause secondly more closely. The distinguishing feature of the mens rea requisite under clause secondly is the knowledge which is possessed by the offender regarding that particular victim being in such a peculiar condition or state of health that the internal harm caused to him is likely to be fatal, notwithstanding the fact that such harm would not in the ordinary way of nature be sufficient to cause death of a person in normal health or condition. This is the most important aspect of clause secondly. The intention to cause death is not an essential requirement of this clause. The intention to cause death is the essential requirement of clause first, not of this clause. Here, only the intention of causing the bodily injury is required, but it should be coupled with the offender's knowledge of the likelihood of such injury causing the death of the particular victim. This clause requires both some intention and some knowledge. Instances of cases falling under clause 2 of section 300, where the assailant causes death by a fist blow intentionally given, knowing that the victim is suffering from an enlarged liver or enlarged spleen or diseased heart. Now, the blow is likely to cause bodily harm and the intention is to cause bodily harm because the blow is given intentionally. Coupled with this intention, there is knowledge that the victim is suffering from an enlarged liver or enlarged spleen or diseased heart, and he has the knowledge that this blow is likely to cause death of this particular person as a result of the rupture of the liver or the spleen or failure of the heart. The source of this analysis is the judgment of the Supreme Court in the case of State of Andhra Pradesh versus Rai Varappu Punayya. Here is clause thirdly. Culpable homicide is murder if the act by which the death is caused is done with the intention of causing bodily injury to any person. So here the intention is to cause bodily injury. And then there is the second requirement. The bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Under clause thirdly, death is caused by doing an act, and this act by which death is caused is done with the intention of causing bodily injury. But there is one more requirement. The bodily injury which is intended to be inflicted by the offender must be sufficient in the ordinary course of nature to cause death. This illustration will explain the position more clearly. A intentionally gives Z a sword cut or club wound. The cut or wound is sufficient to cause death of a man in the ordinary course of nature, and Z dies in consequence. Here, the intention of A is to cause a bodily injury, and the bodily injury he intended to cause was sufficient in the ordinary course of nature to cause death. In consequence, death is caused. Then A is guilty of murder, although he may not have intended to cause Z's death. Let it be very clear that the intention here is to cause only a bodily injury. The intention is not to cause death. Because if the intention is to cause death, then it will be covered by the first limb and there is no need to come to clause thirdly. We shall now analyze the provisions of clause thirdly more closely with the help of a Supreme Court judgment in the case of Virsa Singh versus State of Punjab. The court in that judgment says that the prosecution must prove the following facts before it can bring a case under section 300 thirdly. These are the four components. First, the prosecution must establish quite objectively that a bodily injury is present. A bodily injury must be present. Secondly, the nature of the injury must be proved, and both these requirements are purely objective requirements, result of objective investigations. The third requirement is the prosecution must prove that there was an intention to inflict that particular bodily injury, that is to say, that it was not accidental or unintentional, or that some other kind of injury was not intended. So the prosecution has to prove that the intention of the offender was to inflict that particular bodily injury which is present on the body of the deceased. Fourthly, it must be proved that the injury of the type just described, made up of the three elements set out above, is sufficient to cause death in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. What are the main requirements for application of clause thirdly? As per this judgment, there are two requirements. One is subjective, the other is objective. The subjective requirement is that the accused had the intention to cause the bodily injury which is actually found to be present. He had the intention to cause that bodily injury which is actually found on the body of the deceased. And the objective requirement is that this injury which is found on the body of the deceased, which is actually caused by the offender, is sufficient in the ordinary course of nature to cause death. Once these two requirements are established, then it does not matter that there was no intention to cause death. Once again, I would repeat that where there is intention to cause death, there is no need to come to clause thirdly. The first clause itself is sufficient and the offense is murder. Also, it does not matter that there was no intention even to cause an injury of a kind that is sufficient to cause death in the ordinary course of nature. It does not even matter that there was no knowledge that an act of that kind will be likely to cause death. Nothing else is required if the before said two requirements are met. As I said, the source of this analysis is the judgment of the Supreme Court in Virsa Singh versus State of Punjab, rendered in 1958.